So I also am an author. I authored a book in June about the mental health benefits of psilocybin. Uh, Subsequent to that, got into plant medicine consulting, which leads up to this next book I'm writing, which is about the laws surrounding entheogenic churches in the United States. And then I'm also developing a website, entheoconnect.com, which will be connecting people in the entheogen spirituality community to plant medicine retreats and churches in the US and abroad, as well as other services, combo integration, a lot of the spiritual ancillary services that go along, with the plant medicine, religion, churches, whatever you want to call it.
Great. And I met Greg because I have a church here in Albuquerque called the Church of the Natural Law. And because I have an ayahuasca lineage and a traditional Native American lineage, we were able to develop a lot of the pieces of the puzzle on our own. But I contacted you to find out, how these pieces fit together. So I remember talking about our articles and what we had described. And, you said the more detail, the better as far as, our practices and lineage and all of that. But what are the two main things? I think you said there are two things that the government really cares about in terms of legality with plant medicine.
Yeah. So let me start out by saying this. As far as the religious beliefs themselves, the government's not going to do too much second guessing about those. As far as someone's sincerity, I will tell you this: if the government thinks you're using the Religious Freedom Restoration Act, to say you're in a religion that's distributing drugs like to the public at large, or things like that, yeah, they will call that into question. But as far as holding sacred ceremony, that pretty much entails that your views surrounding the plant medicine, and again, religion, when I say religious, it's really just a term of art here, but they hold a religious place in your life. Okay. And that's just a term of art, term used by the courts to describe the relation of a set of beliefs to an individual. But so with that being said, that would be the what you would have to prove on the Religious Freedom Restoration Act would be that the federal government has substantially burdened a sincere religious exercise, right? So pretty much the mere existence of the Controlled Substances Act is a substantial burden due to the possibility of being arrested, things of that nature, paying fines, is pretty much in and of itself a substantial burden on a sincere religious exercise when we talk about entheogenic churches. So really just by filing in court more times than not, you've pretty much proved that part up. Then the burden switches to the government. And here's what I was telling you about what the courts really look at to show a compelling governmental interest, and that it's the least restrictive means how they're, burdening your religion. It's the least restrictive way to advance that interest. So when we get to that side of the analysis, what we look at is the health and safety of the members of the church at jeopardy through the plant medicine practices and ceremonies? And then two, they also look at what kind of substance, like, is there a chance that these substances, the way that they're being kept and maintained, could leak out into illicit markets? And so there's obviously a lot of factors that they look at there, and a lot of other sub factors they look at when we talk about health and safety. But those are the two main concerns that the courts are going to analyze under a Religious Freedom and Restoration Act claim as far as it relates to entheogenic churches.
Boy, that was a lot of information, and we've talked a couple of times before, and I've been doing a lot of research, so I'm pretty sure I followed you. They're concerned with people's safety, and they're concerned with the controlling of a controlled substance or a scheduled substance,
Yeah.
right? So as long as we're doing these ceremonies in a way which is at least moderately religious, right? And we all certainly have to believe that this plant medicine is a spiritual thing, definitely not a party drug. We don't have to worry about that with ayahuasca, of course. That's not a party drug,
Yeah, no, I get it. And agree.
I don't know about peyote. I certainly wouldn't use it as a party drug, and it counterindicates with alcohol, so that takes a lot of options off of the plate, obviously. But things like DMT. I hate to divert us from the main subject,
Yeah,
but it's
no.
a good question, like a good example. Somebody wanted to open a DMT church where they were going to smoke DMT. Now, how would that work? If everyone sat around and religiously smoked DMT, would it be covered since it's kind of a chemically extracted version?
So that's an interesting question. And so there's a few things that come to my mind when I think about that. Now, one, I certainly believe that DMT could be smoked in a very ceremonious fashion with very sincere religious, beliefs going into that exercise. No doubt about that.
Right,
Um, where you run into with a drug like DMT, though, is on the other side of the analysis, right? And that's going to be this, that the government's going to argue, well, unfortunately, there's a few studies out there that are actually cited in like the UDV case. And I don't even know if this would even be germane necessarily to the court, but apparently there's a study out there where people were intravenously injected with DMT,
oh no.
and one person had like a real high blood pressure, another person had a relapse of depressive symptoms. That's the kind of evidence the government's putting in, uh putting into the record on the ayahuasca cases, which the court found marginally relevant, right? So that's the kind of stuff that the government's going to put in. But I think where it kind of tips the scale in the government's favor is the large illicit market for DMT.
Right.
That's kind of where you get, you know, the chance of diversion increases as the illicit market increases, right? So um, that's kind of where you get there. It's kind of a tough call. I think that if the DMT were handled in a very, very safe manner and put under lock and key, because here's the one thing you got to realize is that the Religious Freedom and Restoration Act is a case by case basis, right? Just because the UDV and Santo Daime were exempted does not make a flat rule that all ayahuasca churches are going to be exempted. But we can extract what the court looked at in those cases in order to tilt the scale on their favor and extrapolate that out into the broader space, and try to keep to those ideas and methods as much as possible. But here again with the DMT, it would come down really to what kind of studies the government, whatever studies have come out since the UDV case about the health and safety of DMT, and then two, what kind of substance handling procedures are involved. I would go ahead and say that they need to be A1 to overcome, just because really the nature
Illicit
of the
market.
market. Yeah.
Sure. Well, that makes a lot of sense. Um, okay, so you've talked about a couple of different cases, and I'm familiar with them already, but I'm thinking that some people in the audience might not be familiar with them. So can we talk about we should probably talk about RIFRA, right?
Yeah.
And then maybe pick one big case or two.
Yeah, yeah, that's fine. I mean, so with the RIFRA, I'll just give a brief rundown real quick. So RIFRA was, and when I say I mean Religious Freedom and Restoration Act, was passed in 1993. So why, and it basically just solidifies constitutional rights. So one might ask, well, why did they have to pass a statute to solidify constitutional rights?
Right.
Well, here's what it is, and I want to make this point here. When I'm talking about Religious Freedom and Restoration Act, it's meant to counteract what I call laws of general applicability, which means that when the government has a law that applies to every single person across the board equally, not targeted at a religion or targeted at a minority group or anybody, like, the drunk driving law applies all the way across the board, doesn't matter who you are, it applies to everyone. Those are laws of general applicability, right? So prior to 1988, even laws of general applicability in a religious freedom context were subject to what we call strict scrutiny. Now, strict scrutiny means that whenever the government's laws burden an individual, it was up to the government to prove this compelling governmental interest in least restrictive means. So to prove a compelling governmental interest is a very high burden, and then mixed with least restrictive means, very, very high burden. So all that was good. Laws of general applicability, strict scrutiny, all the way up till 1988. There was a case out of Oregon, Smith versus Oregon Department of Human Services. I think, I can't remember the exact name, but in that case, the Supreme Court did a 360. And let me make a point about that case real quick, is that it actually involved a Native American man who got fired for consuming peyote religiously, and then he was denied unemployment benefits. Right? They were like, well, illegal drug users don't get unemployment benefits in Oregon. It doesn't matter who you are or what the cause was. Right? So it's the law of general applicability. Well, the Supreme Court does a total 180 and says, well, despite all this past precedent, now we're of the mindset that the court's not going to go into these case by case analysis of laws of general applicability. If it's a law of general applicability, basically it's constitutional. You know what I mean? If the incidentally burdens religious exercise, it's still constitutional because it applies all across the board. So Congress got very upset. I guess a lot of people in America were very upset by this decision, and rightfully so. So within 3 years, in 1993, Congress, with bipartisan support, passes the Religious Freedom and Restoration Act. And basically that takes that pre-Smith burden, the strict scrutiny, and puts it in the statute and plainly says, any governmental action that substantially burdens a sincere religious exercise is subject to strict scrutiny, no matter what. And this is going to be a case-by-case basis. Courts, you're going to have to stop being lazy, and you're going to have to get up here and decide these things on a case-by-case basis. And so since then, that's the law. General applicability doesn't matter. It's the courts are going to have to analyze it according to the strict scrutiny standards. So that's the Religious Freedom and Restoration Act. I'll make one more note about the statute, is that in 1997, a case out of the Fifth Circuit that went to the U.S. Supreme Court, City of Bernie versus Flores, said this statute doesn't apply to the states. So another quick note is that I think 22 states have enacted their own Religious Freedom and Restoration Act statutes. And then other states, and I haven't done a state by state all the way across the board yet, but a lot of the other states who didn't, it was because their laws already provided just as much, if not more, protection than the Religious Freedom and Restoration Act did. So, and one more note to make is that it can be inferred, because the Smith decision involved plant medicines and theogenic plant medicines, that was on the forefront of the Congress's mind when they passed the Religious Freedom and Restoration Act, right? So that theme kind of runs through all this. And so that's the Religious Freedom and Restoration Act statute. Do you want me to keep going into
well, even all this information must be a lot for people.
I've been writing that book this last week, so all this is like right here on my mind. Yeah, I've been intense, neck deep in it.
Yeah, I'm probably a good bridge person on this because, it's in my personal interest to know as much law as I can, because we have an ayahuasca church here. Mm-hmm. And then I was pre-law, and I'm really interested in law. So a lot of the things that you've shared with me have been new. And the one that I was familiar with was the case that happened here in Santa Fe. Mm-hmm. And little background, we ended up having an office in the place where the medicine was seized in that one case. Was it the Santo Daime case in Santa Fe?
No, that was the UDV.
Mm-hmm. Yeah, so that was interesting because the Seagrams guy actually funded part of that because he was involved. Was it Bronfman?
Yeah.
Yeah. So there's a nice documentary about that. Unfortunately, it's on a CD-ROM, so I haven't been able to watch it. But I'm looking forward to seeing that. It's all about the case as it moves through I guess, the district court to the Supreme Court and all of that.
Yeah.
So what basically happened out of that? What came out of that, and what went on?
So what happened there is that, as you already know, I want to say that the UDV, which was an ayahuasca church that originally started in Brazil, that made its way up here, and I think it had been operating maybe almost 10 years or something by the time this happened. I think they had 130 members at the time, but maybe they had a shipment seized at the border, and then eventually they kicked the door in and seized what they had at the church, something of that nature. But I know that they ended up seizing what they had at the church. So, and again, nobody got arrested on these things. The government understands what its burden is under the Religious Freedom and Restoration Act, but at that point they hadn't really been tested. But they didn't want to arrest anybody, because if they went to arrest people, then it later got overturned, it could spell trouble for them. So the UDV at that point, after they seized their medicine, filed for an injunction in the district court, federal district court, under Religious Freedom and Restoration Act. And one important note about that case is that the government conceded that their religious exercise was sincere, and they conceded that what they did substantially burdened the UDV's religious exercise, right? So now we're on the other side of the burden again. The government has to prove compelling governmental interest and least restrictive means. And I'll say this is that when it came down to it, even with the primitive state of the research on ayahuasca at that point, which really just were case studies done by Charles Grob, and then there was one other study where they actually went to Brazil and had studied the church members, took a sample of church members and studied them.
That one, yeah.
Yeah. And so that was all that the UDV really had as far as health and safety. But again, the government, all they had were studies that involved injectable DMT, and then just studies on generally hallucinogens, right? They had no specific ayahuasca studies. And so the government or the court found those other studies just marginally relevant. They were like, this is not relevant. And then the court realized that, wow, okay, in this ceremonial setting, it's actually a lot safer. And ayahuasca is a lot milder than just intravenous DMT, it's
no joke,
it's
right?
milder and so the courts, I will say this, the courts realize that medicines like ayahuasca consumed in a ceremonial setting, it's a preferred setting, it's very safe, it's set for people to journey properly, not to say they might not have a hard process, but it's set up to where they're not just going to completely lose their shit, So the court realized that, and basically the court said, on the record we have right now, the health and safety is about 50-50. So, no dice, government, you didn't meet your burden there. And they didn't even get to the least restrictive means part. But let me go back real quick on the substance handling. They found that to be about 50-50 too, because especially at that point, this was in 2002, there was no illicit market for ayahuasca. The government, all they could say is, well, there's some advertisements online, for it in Europe. That's about it. There's really no market. So, but the UDV did have, substance handling procedures. Only certain people in the church were able to handle it, and then obviously the congregants or their members only drank, their serving at ceremony. So yeah, the government couldn't prove their case. And then it went up to the 10th Circuit, who went back over, in their opinion, all the evidence that had been uncovered at district court and, made comment on it, but affirmed. And then eventually went to Supreme Court. Supreme Court affirmed. And then the Supreme Court also kind of went into some other lofty constitutional issues to do with everything. And in my book, I don't really get too much into that. My book is mostly an analysis of the facts and how the court viewed those facts, because I want people to be able to extrapolate from that practices, procedures, methods that they can then use in their plant medicine churches in order to, you know, feel better and be closer to this protected point over here.
That makes sense.
Mm-hmm.
I'm going to jump on Facebook here for a minute and see if anybody has any questions.
Yeah, absolutely.
What we're doing there.
I love Q&A.
Yeah, be nice to check in with the group and see how everyone's responding. We should be live on there. This is our first time doing this together. I did this in New York a lot, and somebody else always handled it. So this should be interesting to see how my technical skills are.
Yeah.
Yeah, I'm not finding our live feed, but it actually says on here that we're live on Facebook. So somewhere on Facebook we're live. If not, we're recording, so we can always just, put it out there afterwards.
Yeah.
So we might as well continue. Okay, so that is case number 1. You want to pick another big case to talk about? I mean, it's fresh in your mind with your book.
Yeah. Yeah. So, I mean, the other really only big case that there's been was the Santo Daime case, which mirrored in a lot of ways, in many, many ways, the UDV case, other than the government, and I'll make some points out of this, the government actually controverted the sincerity of the Santo Daime's religion, and specifically the religious leaders. So in 1999, this was before this case came to district court in 2009, but in 1999, they had actually kicked the door in of the leader's house and seized a lot of ayahuasca, but they also found some marijuana in there, which the religious leader claimed was his wife's, whoop-de-whoop. But after that event, the Santo Daime went back underground practicing, right? And we're doing it in very secretive manner. So now fast forward 2009, when this case hits the district court, the government tried to use the marijuana found in the man's house against them as doubtful of their sincerity. And then also tried to use the fact that they had practiced underground. Okay, because when the UDV case was decided at the Supreme Court level, they kind of came back above ground after that, right? So there's maybe a period of about 6 years that they practice underground. And so, yeah, this is how ruthless the government is. It's that then they come and try to use that against them, to doubt his sincerity. But the court said, no. One, even if the marijuana was this man's, we're not going to, use the shortcomings of a religious leader, if that's even the case, as a way to cast doubt or throw shade on the whole religion or the congregation. That's just not how it works. And then 2, the court was like, the fact that they continued to practice underground or not after the leader had his door kicked in shows sincerity. And I agree, I mean, you get your door kicked in and you go underground, but you don't stop, that goes towards sincerity. So the court found, yes, this was substantially burdened to sincere. Oh, and I'll say one more thing. After the door got kicked in 99, they attempted to negotiate with the Department of Justice, some kind of agreement that the government could regulate their import of ayahuasca, but the government didn't want to have anything to do with negotiating with them. So again, that kind of drove them underground. But, as far as the health and safety and the substance handling, again, it was, pretty much equal. As a matter of fact, when it came to the substance handling, they actually found that the Santo Daime, actually, the evidence might have even pushed a little bit in their favor. So, and that's because, some research had been done in the interim, but, the studies had been developed on the health and safety side, and so, but it was still kind of about 50-50 because the studies were still primitive at that time. But again, 2006, evidence wasn't enough to overcome, or, the government couldn't put up enough evidence. 2009, they couldn't put up enough evidence. And as we know today, the research on ayahuasca has developed quite a bit, and pretty much everything I see is good. So, as this research on these entheogenic substances develops showing safety, the government's ability to prove, their side under a RFRA claim is steadily diminishing.
That's pretty amazing. It's really exciting because for a long time, for the past 10 years, as I've been working with plant medicine, there's been a lot of concern about whether or not it's legal, what could happen. Can you even find an attorney who would be willing to argue your case? You know, uh, with any amount of money, I was not able to contract an attorney to actually even dialogue with me about this. And so it was really scary. And it really takes away from the happiness level of the participants when you feel like anything could happen at any time.
Yeah.
So we're approaching 100% security around the issue, I hope.
Well, and again, it's a case by case basis. So, to sit there and make a blanket statement like that, I just can't. But I mean, I will say that if people pick up on what I'm saying tonight, pick up my book and take a look at it and really digest the points that I cover from these cases, and just apply that to their practice, they'll be approaching the protected status, right? And look, as long as you're having a sacred ceremony where these substances are being taken for spiritual purposes, that pretty much covers the first part of it, the sincerity and all that. Then it just comes down to safe practices. And one thing I forgot to mention is that the court does look at screening practices. Are these people being screened prior to engaging in the ceremony is a very, 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 very important part of it. Because the court is very much aware of the possible bad combinations with medications or prior medical history, right? So it would behoove anybody running a sacred ceremony to do your research, figure out what medications are contraindicated with the medicine, find out what past medical history is contraindicated with the medicine, make you a written waiver form, a written screening form, and really put time and effort into screening these people, right? And keep those records showing that that's what you do, okay? Because that's going to be very important to the court, that you're not just letting anybody come in there and consume the medicine. And then obviously it kind of goes without saying, don't let anybody in your ceremony who's not there to consume the medicine for sacred ceremonial religious purposes. Don't let someone who's in there just to get kicks participate in your ceremony because you want to make a couple $100. Like it's the court looks at those things, right? So those are very important.
Also, from my point of view, running ceremony, it's really important not to let anyone in who's not taking it seriously because it's
Yes.
disruptive for the other participants. And invariably, those are the people who either have complaints or inappropriate remarks, and sometimes they've flown under my radar, by saying, "Oh, I'm in recovery." Right. But they're still not taking the medicine seriously, religiously or spiritually.
Mhm.
They want to use it for their own purposes. And it's great. I mean, it's wonderful in recovery. And it's been so helpful to so many people. It's helpful with PTSD, it's helpful with all kinds of trauma. And if substance abuse is just a form of kind of masking trauma and taking down the pain level when people have a lot of anxiety or trauma, then that's great. But if they're not taking it as a religious experience or a spiritual experience, it gets a little bit hairy. Those are
Yeah.
always the people who go off the rails, and it's just difficult to run ceremony with
Mhm.
people who aren't taking it seriously. So
No,
even from my point of view, it's just no fun.
yeah. So, I mean, I guess that's kind of a two prong there.
Yeah.
One, the court doesn't like it, and two, the facilitator and other ceremonial participants don't like it. And it's not fair to anybody involved, to let those people in because, and I get it. It takes money to run these ceremonies. I get it. But I wouldn't put that above keeping the sacredness and the sanctity of what's going on, priority.
Oh, for sure. Um, and then the screening process, I've been not playing dumb. I mean, we have a medical intake and release form. We ask people what kind of prescription medications they're on, prior health concerns, mental health issues, and all of that. But when they ask me what might counterindicate with ayahuasca, I tell them to look it up themselves. I give them a link to a few different places, but since I'm not a doctor, I don't want to get caught giving medical advice. Does that make sense?
No, it does, and I see where you're coming from. And I will say this, churches like the UDV actually had medical people either here or in Brazil that had developed these screening forms. So I would say this is that, if you don't have a doctor that's part of the church, or you can't pay a doctor to be on staff, at least find some kind of medical professional that can help you draft a screening form, right? Because just because you're asking people questions about their medication doesn't, you're not necessarily giving them advice, you're allowing them into your ceremony or not. So really it's up to you. You're not telling them one way or the other whether to take something or not take something, but allowing them to, whether they, depending on what their answers are to your question for, your questions on the screening form. But yeah, I would have a medical professional just help develop that document, according to their knowledge of what the possible contraindications are, with whatever, plant medicine you might be dealing with. Um, because, like, again, those types of things, I would say probably 25 to 40% of the health and safety is going to be in a court's analysis is going to be centered around your screening process.
Interesting.
Yeah.
Well, I'll keep that in mind.
Mm-hmm.
As soon as I can find a doctor who's willing to speak to me about that type of thing, then I'll get right on it. But the
You, you
doctor's
know,
also been reluctant to speak about the issue because of the liability.
yeah. So get with me later on. I think I do know a doctor in New Mexico who might be willing to help you
Give
out in
the
that
list.
regard. Mm-hmm.
Yeah, because the studies around SSRIs and all of this, everyone has different opinions, and there are now a lot more studies. And the ones in Brazil, when they're talking about people getting off of an antidepressant, um, they show that you can actually wean people off of it
Mm-hmm.
while they're taking ayahuasca. And yet other studies show that it can be risky. So we're still pretty unclear on that piece,
It is, and I will say this is the courts are aware of serotonin syndrome, and now some people say one way or the other about it. But I'll say this: the court thinks it's a thing. Okay, so
Okay.
yeah, yeah. So that's and this was in 2009. Maybe there's been research they would find more definitive the other way, but 2009, the word serotonin syndrome were mentioned in a court case. So I know that another court today, all other things being equal, is going to see that in that prior opinion, and that's going to be something that they're looking for, right? So I would venture to say that contraindications with SSRIs in that class of drugs is going to be on the forefront of their mind.
Good to know. That was a big question that just got answered. Um, okay, well, we have a few minutes left. We were going to go about 45 minutes, and I think we're at about 40 minutes here now. So, last but not least, this question keeps on coming up about whether or not you have to be Native American in order to be legal, or in order to actually partake in these ceremonies. I'm in a unique position of being half Native American and half European. So I look
Mm-hmm.
like this, and Native people will say, "Oh, who's this white lady serving medicine? She
Mm-hmm.
has no right." And people will get very agitated about this. And as I said, for the record, half white, but I'm not sure that race actually matters. To me, in my lineage, what mattered was training. So what mattered was, who are you trained by? So I was trained by a traditional medicine man who has an ayahuasca lineage that goes back to a Taita in Colombia. And these are the big dogs of the whole thing. A Taita might have several dozen villages that they oversee where there are ayahuasca ceremonies going on. So our lineage comes from that. And yet I'm still being told that because of the color of my skin or lack of a reservation card, that I'm not supposed to be able to make ceremony. Um, okay, so we can set aside morally and philosophically how we feel about that. How would the government feel about that? If this comes to a court case, are they going to ask me for my reservation card, my Indian identity card?
No, and I tell you, I have heard from quite a few people that it's been told to them from various sources that if you're not connected to this church or that church, you're not protected, right? And usually it's a pitch, come pay us some money and you'll be protected. You know what I mean? It's not really have you done the training, anything like that, but it's pay us this money, you'll be protected. But that is all bogus. Now I will say with the Native Americans in regards to peyote, they're protected under other statutes other than the Religious Freedom and Restoration Act for that specific practice, right? But we have the Religious Freedom and Restoration Act. When you read the law, it says nothing about lineage. It says nothing about being tied to any church or religion. And in the standard for being sincere and being religious is very, very low, and the court's not going to question it. I mean, basically, if you are consuming entheogenic substances as part of a religious practice, and that religious practice involves communing with spiritual forces, through the use of entheogens, it's going to be sincere and it's going to be considered religious. And that does not matter whether it's tied to any specific lineage, culture, any of that. Now, I will say, for instance, let's talk about ayahuasca. If you're running an ayahuasca church where there's traditional healers coming in, traditional shamans that you have run your ceremonies, or if it's someone who's maybe American, like me, but I've spent 7 years in, Peru training to do all this, I'll say this. Whoever you have serving, whoever is leading the ceremony, they need to have some kind of training and know about how to serve the medicine in a ceremonious fashion. Because, like I said earlier, the courts put that into the safety argument, right? So, like, the more better that the ceremony is held, the more they consider that on the safety side. So, my suggestion would be to have someone, a native South American healer or someone who has done this extensively, run your ceremonies. But whether they're tied to any specific, you might have someone from South America come up from some random tribe in Peru or Brazil, like who have different religions or kind of different beliefs as it relates to this stuff. But the court's not really necessarily concerned about that. It's just the overarching, are we consuming these as a religious practice? So yeah, no, there's no requirement that you be tied to any set religion or lineage. It just really boils down to, is it sincere? Is it religious? And those questions aren't tied to lineage or culture or anything like that.
Or race?
No, or oh yeah, especially no,
Especially
not at all.
race. Yeah.
Yeah, especially not. And I'll say one thing real quick is, I get a lot of people who want to start a mushroom church who've been using psilocybin for a very long time, in a ceremonious and religious context. But as we know, there's really only one lineage per se that's well known out of Mexico, for the mushroom religion. But like I tell people, psilocybin mushrooms have been used by man for, at the very least, we know 10,000 years, if not longer. In my view, it is probably one of the most sacred, or if not the most sacred, of entheogenic sacraments on earth. And so, again, my view is that you could take your own beliefs with psilocybin, working with psilocybin, and take your own ceremony that you put together, and put that down and start practicing it. My view is that if all other things being equal, that's a protected activity, in my view. That's just my opinion after reading the cases and knowing what I know about the law in this area.
Wow. Um, there's been a lot of information, and it's always a pleasure speaking with you.
Yeah.
Um, as I mentioned, most attorneys for a long time wouldn't come anywhere near these questions, let alone, speak out. So I really appreciate your courage and your conviction in the matter. And when do we get to see your new book? I really enjoyed the first one. So, what, psychedelics and mental health, right?
Yeah, so that was the first one. I wrote this one. I started this book last Thursday. I should have it finished tonight, the rough draft, maybe tomorrow. And then I'm going to send it for editing, give it a week, and then format 3 or 4 days. So about 3 weeks, uh, I'll have it published on Amazon, ready to go.
Ooh, so by Christmas time, people can expect
Yeah.
to gift people this book to their family members.
I would love for them to. I think it would be a great gift for the plant medicine aficionado in your family.
Yeah. All right. It would be an unusual Christmas present, but for those boomers out there who are looking to give something to their grandkids,
Yeah.
it might just be, might
It's,
just be a good one.
I'll
Right?
make it stocking stuffer size.
That would be great.
Yeah.
Okay. Well, hopefully next time we can take some questions, and we can definitely go in and take questions out of this, assuming it's live on Facebook somewhere out there. Then we'll be able to get some questions and do another one next week.
Yeah, I look forward to it. Just let me know. I guess we'll do same time and shoot me an outline, and I shall be prepared.
That sounds great. I'm